Okay, we're back for part 2 of chapter 10, so let's go ahead and jump right in. So if you're following along in your book, we're on page 308, right about in there. Okay, so now let's talk about mistaken eyewitness testimony. Now, mistaken eyewitness testimony is the most frequently identified factor in wrongful convictions. And we know more today about the vagaries, if you will, of eyewitness memory than in previous years. And research shows that memory, is not as accurate as some people might believe, including jurors. Mistaken eyewitness testimony may not involve any wrongdoing on the part of the police or prosecutors. And I think we really need to understand that. However, in some cases, improper police or prosecution behavior influenced witnesses to identify the wrong person. So it's not necessarily that there's any ill will, etc., or the officer or the prosecutor meant to do this wrong. But the fact is, let's say if a process or a procedure is wrong, then that's going to kind of just cause the domino effect, right? So again, mistaken eyewitness testimony typically, it says here may not, but typically does not involve any wrongdoing on the part of police or prosecutors. But in some cases, some of the behavior or processes in place might influence a witness to identify the wrong individual. So it really is important that we understand that. Now, police officers may repeatedly ask victims if they were sure that the suspect was not the person in the lineup or the show up, etc., that, present only one person to the witness instead of a lineup. And part of this, the U.S. Supreme Court rejected the argument that judicial review of eyewitness testimony was actually necessary. So, it kind of leads us to believe that because they rejected the argument that review of eyewitness testimony was necessary. But on the other hand, you have to understand, given the research that showed how faulty it was, why would it not be something that would want to be reviewed, right? So it kind of makes sense. So it kind of, it leaves it to the prosecutor's offices to ensure such testimony is basically credible. Now, suggestions include using sequential identification, since witnesses feel pressure to pick one person from a regular lineup, even if none of the people are the suspect, and then what they call double-blind identification, where the law enforcement official does not even know who the suspect is to avoid perception. Now, without going into a lengthy discussion, an example would be, this is considered to be like a 6-pack photo lineup. And the individuals are supposed to look similar. Now, they're not the same, right? And the thought here is that if you show all 6 pictures at the same time, then people feel pressured thinking that the suspect is in here, so they're going to pick the one that looks the most like the suspect. However, if you did it sequential, meaning that you showed just this picture first, and the person says, okay, that's not him. Then this picture next, okay, that's not him. And then you go down one at a time, that it's a fair process, because the person should be able to go, wait a minute, that's him, when they get to that picture, instead of the contest kind of figuring out, like you were taking a test, right? Which one is the closest to what I saw? So that's sequential versus standard or a regular lineup. And this can be done in a photo lineup or a live lineup with people. And then the double blind is where somebody not even affiliated with the case does the photo lineup, if you will, or the live lineup, so that way that person doesn't even know who the suspect actually is. That's kind of a double blind. So, and a great case to kind of do a study on or look at would be the Ronald Cotton, Jennifer Thompson case. They wrote a book together. They actually do a lot of interviews and workshops and things on eyewitness testimony. So a fantastic, good case study for you guys to take a look at. Okay, so now what about false confessions? So we have like the eyewitness testimony. Now, false confessions are another important factor in wrongful convictions, right? And if you remember in chapter 6, we covered how police behavior can induce a person to confess by coercive or deceptive in interrogations. But sometimes prosecutors are also complicit in participating in or using, false confessions. And false confessions are so powerful that juries have convicted individuals even when there is exculpatory DNA evidence. Remember, evidence in favor of the defendant, right? That's introduced at trial. And a great example would be the Norfolk Four. Four sailors who were convicted of rape and murder in 1997. And they alleged that they falsely confessed to the crime because of the coercive interrogation tactics of the investigator at the time. And he told them that if they didn't confess, they would basically die, and there was no other evidence to link them to the crime. And before they were brought to trial, another man who knew the victim confessed, admitting that he did it alone, and his DNA was also found at the crime scene. Yet prosecutors, they continued with their case against the Norfolk Four. And at the end of the day, these four served 8 years before being released. Or one of the four served 8 years before being released, but the other three were still in prison until being pardoned by Virginia's governor in August of 2009. So again, it's not a perfect system, and it's a horrible reminder that things don't always go right. So false confessions. Well, what about racial bias? Whereas some cases probably involved pure and extreme racial prejudice, and we know that some have, a prevalent factor in false convictions is a more subtle form of racism, if you will. And many in the criminal justice system tend to prejudge the guilt of the accused, especially if they are black men. Okay? And, a pervasive stereotypical belief that all defendants are guilty, and along with that, a disproportionate number of the defendants are black. So, this thought pattern of those individuals that think this way shapes and distorts decision-making on the part of the prosecutors, who may, sift and use evidence in a way that will support these predetermined beliefs. Now, also noted is a higher rate of error in cross-racial identification, stereotyping, and a lack of resources among minority defendants. So all of these things need to be taken into consideration when we form these different processes. And the two pictures I have here, so just kind of a little thing. Let's just say that you're a police officer and you're driving in the middle of the night, wherever in a area where there's not that many people, and or you pull a car over and you stop this person, and then you pull over a car and you stop this person. Are you going to treat them both the same? Do you view them both the same? Are they both innocent until proven guilty? And it could just be, the tattoos make this guy look more whatever, right? But, this is my buddy JT, in case you don't know. Anyway, just kind of a little exercise for you to think about. Do you see them the same in the eyes of the court? Enough said. Okay, now we're going to talk about something called confirmatory bias. And confirmatory bias is when someone ignores the evidence that is contrary to basically what they believe. And confirmatory bias may lead to wrongful convictions because prosecutors, again, ignore the evidence that tends to refute their theory of the case. And it might even lead to the noble cause corruption. If you remember, we talked about that back in chapter 5. And just as, police may commit misconduct when they think that they have the guilty party, so too may prosecutors bend and even break the rules when they are sure that that defendant is guilty. And again, there's a very small number of cases, but the fact of the matter is there are still cases. Now, what are some of the explanations for misconduct? Well, the ideal or vision of our justice system is that it is fair, unbiased, and through the application of due process arrives at the truth before finding guilt and then, of course, administering or assessing punishment. Now, the reality here is that the law is administered by humans with human failings and that errors and misconduct result in innocent people being convicted, incarcerated, and sometimes even, unfortunately, executed. So we're going to kind of take a little bit of a longer look at some of the explanations for misconduct. So, in the discussion of wrongful convictions earlier, confirmatory bias was described as related to the noble cause corruption, in that once there's a determination that the defendant is guilty, police or prosecution here, the perception might lead to misconduct just to make sure that they get a conviction. Now, there's a couple of other things to consider here. Gromstein in 2007 also applies the concept of noble cause corruption to prosecutors, arguing that they adopt a kind of utilitarian ethic of using bad means, if you will, to get a conviction. And we do have to kind of understand that, again, no system is kind of perfect here. But what we want to do now is look at the psychological process that might contribute to misconduct. So, and again, we're talking about prosecutor misconduct. So the tendency of, or the presence of, confirmatory bias, meaning the human tendency to seek to confirm rather than disconfirm. Selective information processing, really only recognizing evidence that fits, one's personal theory, despite maybe evidence to the contrary, right? Belief perseverance. Again, believing one's original theory of the case despite evidence to the contrary. And then avoidance of cognitive dissonance, which basically means adjusting beliefs to maintain existing self-perception. So these are, several authors discuss different psychological processes that contribute to misconduct. Now, Cummings in 2010 used Bandura's moral disengagement theory to explain intentional prosecutorial misconduct, concentrating on 3 types of the most relevant things, as it relates to prosecutors. And the first one would be reconstructing conduct as morally justified. Next, obscuring personal agency. And then last would be blaming or dehumanizing defendants. So again, just a few different things for us to kind of look at. And again, as we kind of back up, and I'll finish and then we'll move to the next section here. The first type here refers to noble cause corruption. So if we kind of go back here, prosecutors, like police, feel that they are on the side of righteous, and so they, what they do can be justified. The second relates to the office, policies having like batting averages, if you will, and pressure to convict that make it difficult for a prosecutor to express anything other than a strong conviction, orientation or thought process. And the final idea is, again, like police, and that the culture of some prosecutors' offices includes kind of an orientation towards defendants that dehumanizes them by using, different words and things like that. So that's kind of the meaning, if you will, to these three items. All right, so now what about judges? So the immunity of judges insulates them from the effects of their decisions, although their decisions are public, and those public decisions can, of course, create some storms of controversy. And their case holdings may be scrutinized, and their courtroom behavior may also be grounds for an appeal. Even so, it really is difficult for attorneys to challenge a judge's actions or even testify against them in a disciplinary proceeding. So, at the end of the day, thus some judges, kind of evidently believe they are invulnerable and basically use their office as kind of their own personal throne, if you will. We can all get that big inflated brain, right? And think that we're above all others. Now, judges, as you would think, have immense power. And as the saying goes, power can corrupt. Or, it can anyway. And state judicial commissions rarely sanction judges, and voters tend to be kind of oblivious to the reputations of different judges. A lot of times when the elections come around and you're going to elect judges, do you even do your homework as just a regular citizen, right? So a lot of us don't really know about the reputations of our particular judges. Now, to enforce the rules, so here's kind of responding to some of these things. To enforce the rules of ethics, the American Bar Association basically has a standing committee on ethical responsibility to offer formal and informal opinions when charges of impropriety basically have been levied or made against a judge. And also, each state bar association can sanction offending attorneys in private or in public. But with that being said, when you talk about disciplinary issues, only 3% of investigations by state disciplinary committees result in public sanctions, and only 1% of these investigations actually end in disbarment. So again, when you're talking about attorneys, if you will, and it seems that prosecutors may be even less likely to be the target of bar discipline committees than criminal defense attorneys. So we already talked about the percentages there. Now, such information, again, is hard to access because disciplinary proceedings may be secret, but the numbers of prosecutors investigated, much less sanctioned, seem to be very small, actually as low as 2% of all complaints that result in discipline. So here, again, we're talking about defense attorneys, and here we're talking about, prosecutors. So what can we do to kind of, fix it or what have you? So a lot of things talk about better training and supervision, et cetera. So there is some argument that prosecutors don't get enough sufficient training on things like Brady obligations that lead to some of the Brady violations that appear in wrongful convictions. Remember, that's where you're not disclosing exculpatory evidence, right? And perhaps we should require prosecutors to work with the Innocence Commission to counteract the psychology of conviction at all costs would be helpful. But I mean, everybody wants to win. The prosecution certainly wants to win, and the defense attorney certainly wants to win. And winning is, as we've said in other lectures before this chapter, it is part of the adversarial process. You as the defense bringing out the facts, you as the prosecution bringing out the facts, and now all the facts are on the table, and then the trier of fact, which is the jury, they get to decide. But maybe some better training and supervision might be something that could, be helpful. There should also possibly be clear and public policies in each prosecutor's office concerning the use of jailhouse informants. And of course, turning over that exculpatory material, which really is, super, super important. What about maybe having what they call conviction integrity units? And this is something that the Innocence Project really kind of backs, if you will, and affiliates or really backs the fact that we should have more of these. And while the number of innocence projects is growing, and the groups have been successful in identifying cases, and they are prevailing in court, they can't be the only solution to the problem of false, conviction, right? So maybe having some of these conviction integrity units might be something that could be helpful. Mandatory DNA testing. As mentioned earlier, DNA has been the vehicle by which many innocent prisoners have obtained their release from prison. And even after many years, a small amount of preserved DNA evidence could exclude someone or help to identify the actual suspect of a crime. And some states have mandated DNA testing of old cases when the inmate requests it, but still other offices, however, actively oppose retesting of DNA. So maybe this mandatory DNA testing might be something that could actually be good, right? And then I have here some information from the Supreme Court on a case, District Attorney versus Osborne, that you can take a look at. And then what about private crime labs and enhanced due process procedures? So, this kind of really comes down to testing, DNA testing through like those genealogy companies. So because of the pro-prosecution bias that is said to exist in state or local police crime labs, now this is kind of a little bit far-fetched, but some people think this way, there have been calls for private labs to test the evidence. More than half of all labs in the country report directly to a law enforcement agency. And sometimes the bias is direct, but more often it's subtle, and examiners may not be aware of how they kind of slant findings to the prosecution, which would be kind of a cognitive bias, right? And while there is an argument that, private labs would not be subject to the same cognitive bias as employees of law enforcement agencies might be, a contrary argument is that examiners would still feel pressure because their continued contract with that agency or that city, right, would be the incentive to produce favorable results. So is that really worth going to a private company? If you contract out, they're going to be pressured to do well and give you what you want. So there's kind of, a little perceptual issue right on both sides. And maybe a hybrid version or suggestion. Most testing might be done at the state crime lab, but periodically evidence would be sent to a private lab for maybe verification testing. These are all some different solutions that are kind of out there. And, you know, it might not be a bad idea to look at. And we already talked about, let's see where we end up. All right, we talked about the crime labs here. Okay, so, you know, what about, again, we're still talking about due process, maybe increased accuracy on identifications, which would be that, you know, sequential photo lineup that I showed you, not the 6-pack, but one photo at a time. Maybe the double blind execution of a lineup. Better procedures to ensure that confessions are obtained within a manner, you know, authorized by law. Maybe eliminate use of jailhouse informants because of the high probability that they are lying in order to get some benefit. But a lot of times jailhouse informants are found to be reliable. So again, it's kind of one of those, you know, how do we make sure that we're getting what we need and doing things lawfully and not putting somebody's freedom at jeopardy? Now, a couple of other suggestions. There is a new attention to and interest in addressing the weaknesses of the justice system to reduce the number of those wrongfully convicted. And it's important to note that, you know, the new rules, sanctions, and guidelines that address jailhouse informants, confessions, eyewitness IDs, and other factors have been identified as contributing to wrongful convictions will be effective only if there are ethical legal professionals committed to justice for all. So while all of these are important, right, and all the new guidelines, jailhouse informants, they're important, but there need to be guidelines, confessions, eyewitness IDs, all of this. They're successful a lot of times, but they've also contributed to wrongful convictions. So as we talk about new rules and new processes or procedures, those that are involved in that need to be ethical, legal individuals committed to justice for everybody. Now, a couple of authors, Sullivan and Posley, argue that the way to reduce misconduct includes these 4 things. One would be instituting an open file pretrial discovery requirement on prosecutors, similar to the Morton Act in Texas that could even, you know, substitute for the Brady Rule. You know, abandoning the harmless error test for reversing convictions, even if there is sufficient evidence of guilt. Serious prosecutorial misconduct should be met with a reversal. Identifying errant prosecutors by name in trial and appellate opinions. Stripping prosecutors of full immunity and give them qualified immunity instead as protection from civil damages for misconduct. And then finally, authorizing the Department of Justice Office of Inspector General to handle investigations of alleged misconduct by federal prosecutors. So just a couple of ideas or other suggestions. Okay, so now we're going to start to kind of wind down. We're going to talk a little bit quickly about judicial independence and the Constitution. So judges utilize great discretion that should be used without bias. And like the rest of us, judges are grounded in their personal ethical belief system. And, you know, implementation of law, as with, you know, the creation of law, can be a political process. The judiciary is supposed to be separate from the executive or legislative branch of government, but is it? And out of this, 2 basic philosophies regarding how to apply constitutional principles are at work in the legal arena. And the first group we call strict constitutionalists, because they argue that the Constitution should be implemented as written. And if any changes are to take place in rights, responsibilities, or liberties, the changes should take place through the political system or Congress. Now, I'm just going to give you my 2 cents. I don't think that's probably the right way to do it, but that's just me. And then you have the interpretationists or activists, and they have a looser reading of the Constitution and read into its rights that the framers might have recognized or that should be recognized because of evolving standards. And they argue that the Constitution is meant to be a living document and that the language of the framers was intentionally written as to accommodate interpretation based on the changing times and circumstances. So that's kind of an interesting thought, right? My kind of 2 cents is that I believe that there needs to be a group that interprets the Constitution because sometimes the areas are so gray, but I don't believe it should be political individuals. I believe it should be the United States Supreme Court. And they are by law and by the Constitution, those individuals that can interpret the Constitution. But that's just my 2 cents. Now, and here are basically, as we kind of finish up, we're talking about people's natural rights, the right to be free, to be treated equal to other groups, to be able to make decisions about personal matters without governmental interference, to be free from torture and punishments that degrade the human spirit, and to have protections against state power. All right, so we kind of wrapped it up at a pretty decent clip, so I certainly appreciate your attention. And with that being said, that's going to conclude part 2 of chapter 10, Ethical Misconduct in the Courts and Responses.